Hey everyone, my name is Daniel. I'm a third year arts law student at the University of Sydney with a deep passion in helping law students tackle their way through law school from the early stages in their career to even the later ones. Now, if you're a later student sitting here, you would know how difficult it is and how difficult it was to get into that first judgment that you had to read, to navigate your way through a case, to understand what it was the judges were saying, and to even know what to draw from it at all. So that's where this video is coming to help. This is going to be a little crash course on how to read a judgment. Whether you haven't started law school yet and you're looking to get ahead and develop some of the skills early, or whether you're at the very start of your degree and you want to start getting ahead and keeping up, or even if you're in the later stages of your degree and you want to return to look back at, well, what's most important for me to understand? How can I draw some knowledge from this reasoning, and how can I use it to succeed in my exams and problem questions? Then this video is the one for you. So the basic plan of today's video is looking at the basics of reading a case and looking at how to even approach a judgment before you set your eyes upon that page. Next, we'll look at what to do with and how to understand the facts of a case. And then we'll look at the most important part of the case, the ratio and the reasoning of the judges, and we'll have a look at what to even do with that. Then finally, we'll finish up with looking at the conclusions, dissenting judgments, and some other particular issues. We'll spend today's video using a particular judgment to practice. I've put the citation on the screen. It's a case of undue influence, titled Johnson and Buttress. In light of that, let's start with the very basics. What we're going to do before we even set our eyes upon the page that we've got for the judgment. And we're going to start with looking at the citation. So when we look at the citation, we think, well, what even is it? What is the citation? So the first name in the citation signifies the plaintiff, which is the person bringing the claim. The V sort of indicates a versus, but in at least the Australian system, it means and. And then that second name is the other party, so the defendant. You may notice cases where the Queen, the King, the Commonwealth, New South Wales as a state are parties to the proceedings, and that's all very normal. That means that the state, the Commonwealth itself, or a particular minister of government can indeed be the party to general legal proceedings. Knowing who the parties are is of fundamental importance to understanding the case. Importantly, you want to know who the parties are so you know who is who as you're reading the judgment. It will literally help you keep up. The next few facts beyond the names of the parties are what else is involved in the citation. So the date is the date of the case. Whether there's round brackets or square brackets indicates whether or not it's a reported or unreported judgment. And then the following numbers and initials signify where the case is actually reported, especially if you want to search up the judgment at all, or even look in physical books and see if you can find it. Anyway, a lot of that involves particular issues that are more relevant for your legal research, but when you're actually getting into the case itself, the main thing is to know who are the parties, who's the plaintiff, who's the defendant, and how can we really approach understanding the facts of the case that we've got at hand. So now that you've understood the citation, there's still one other thing we want to do before we even set our eyes upon the page, and it's important to know what you're even reading. Now, you might be asking me that, what do you mean? What are you even reading? How are you supposed to know what you're reading before you even touch the case? What I mean is the topic that you're looking into. If you've ever had the scenario where you want to read an academic paper or a book, but you just want to find out sort of what it's about before you get into it, in order to understand the content even better. What I mean by actually understanding the topic is even a quick Google search or consultation with your relevant reading guide from your university to tell you what's the theme of the case about. So for our purposes, if we think of the case of Johnson and Buttress, for example, we're looking at a case of presumed undue influence, meaning where there was a contractual agreement that may be vitiated because one party exercised a degree of influence or control over the other. So keeping that in mind before we even get into the judgment is really, really important, because we want to know, well, what are the parties even in dispute about? And then what the judge says may cover a range of different issues, but we want to make sure that we hone in on just those ones that are going to assist us for our final exams and our problem questions. Now, it is worth noting there's lots of stuff in these cases which is important and is relevant. For example, when we're looking at the case of undue influence, there may be plenty of times that judges are talking generally about the law of equity, what the courts can and can't do. This stuff may be interesting, it may be important, but for the scenario of you guys answering your problem questions, getting your rules, and using these cases for analogy and for understanding, it is best to focus on just those particular issues that you've looked at and what your topic dictates that you must understand. So now that we've gone over the basics, let's have a look at the facts themselves. The facts are typically located at the beginning of the judgment. And it's worth noting that some cases may involve a bit of a procedural history. What I mean by that is if the case is in the High Court, for example, there's a really high chance that there were plenty of other judgments before that. And sometimes the judges of the High Court, actually more often than not, will engage in a bit of an analysis of what the other judges found and some of their reasonings, almost like a summary. Now this stuff, yes, can be useful. It can be useful for understanding where the opinions of the High Court, for example, are going to be coming from, but generally it is not essential for your reading. What you're getting out of the case is what the High Court has said, not simply a summary of the procedural history. So when we're confronted with these pages and pages of facts, what do we really need to do with them? So, in my view, the purpose of understanding the facts is twofold. One is that you actually want to understand the facts to keep up with the judgment, and you'll notice that this comes up a lot. Judges throughout their reasoning will reference facts that they mentioned without explaining them again. They'll establish them at the beginning and expect the reasoning to simply flow on from those facts. So as the reader, it's your duty to understand the facts that you've been given so that you can understand the judge's subsequent reasoning. But then in terms of what to use the facts for, they're really, really important for your problem questions. Now, it really depends on the topic you've been given, but there are lots of cases where the reasoning of the court is very unique to a set of factual circumstances that you may be able to apply in problem questions or subsequent analyses. So when you're reading other judgments, you can compare what the judges in your case thought based on the facts to the other case that you may be reading. It's easy for law students to get away from the fact that judges are actually ruling on that particular case based on those unique facts that they've spent a long time learning and establishing. So they're not something you can simply discard. It's something that's really important to understand the judge's reasoning and for comparing it to subsequent analyses that you may end up doing. So let's have a look at this particular judgment, which we're going to look at today. We're going to have a look at specifically Justice Dixon's judgment from the case of Johnson and Buttress. The reason we're going to look at this case is for a number of reasons. We're going to work on identifying the particular issues that we're going to talk about, but for now, we're going to start by identifying the facts of the particular case. So what we're mainly going to be looking at with this judgment is we're going to see that there's a very long factual circumstance. You can see that Justice Dixon does indeed set out what the trial judge said, and he makes his own sort of summary of what was held. So starting with what's most important to us, we know that the transfer of property was done by John Buttress, and that's an important material fact to us. We know from the present facts that Johnson had known the family of the deceased for more than 20 years. We also know that Buttress was peculiarly dependent on others. He was illiterate, couldn't even write his own name, and then Justice Dixon explains why this may be, but we also see that he was in a particular emotional state of anger, grief, or objection. He was emotionally vulnerable. And moving on to the next page, we can see that he was easily moved towards shouting. We know that at a particular time in the facts given, Buttress had announced that he wished to make a will in favor of Johnson, transferring all his property to her, including the house in question, which was indeed his sole asset. So what we can see is that there was a really extensive amount of facts given, but we learned what was most important to understanding the case. We learned of the conditions that Buttress was under, the nature of his relationship with Johnson, which is obviously what's going to be most important to us in looking at an undue influence case. We're looking at the particular vulnerability that Buttress may have had towards Johnson to render the contractual obligation voidable. Your tutors are not expecting you to understand all the facts of this particular case. It's just not something they want you to do. And what's really, really important actually, and what they're teaching you as law students is practicing drawing from the facts what are material facts. There's a whole debate about what material facts even mean. But in our case, the material facts are the facts that are going to be essential to the judge's reasoning and therefore essential to the ratio. And of course, what we're actually going to use in our problem questions and exams. Hey everyone, sorry for the little interruption in the video and for the change in audio quality. This is me at a different time. I realized that this video on how to read a case is going to be a lot longer than I expected it to be. I spent a lot of time getting into the facts, and I hope you found that video really useful. But what I think I'm going to do is split this video up into 3 parts. I'm going to talk about the facts, which you guys just saw, talk about the ratio and the reasoning in the next video, and then follow on with the videos after that to talk about some other things that are useful with the case. Let me know if there's anything you thought I missed with the facts, or if there was any part of the video that you didn't enjoy that I can try and include in the next one. But I hope this video was useful, and thanks a lot. See ya.